May it please the court, I represent Roy Rice, the appellant in the case. Today I will argue that the ruling in favor of the plaintiff, Ms. Kraft, was erroneous and sets a dangerous precedent that overly expands the scope of liability under the tort of intentional infliction of emotional distress. While emotional harm is a very serious matter, this court must also protect against subjective and unquantifiable claims that lack objective evidence or the safeguards of traditional tort requirements, such as physical injury. I ask that the court to reconsider the standard applied and reverse the decision against my client. The facts of this case are relatively straightforward. The plaintiff, Ms. Kraft, alleged that Mr. Rice's words and actions caused her severe emotional distress. She described experiences akin to being in a hostage situation, and she claimed that his threats and behavior made her feel terrorized, frightened, intimidated. However, it is undisputed that there was no physical contact or injury that occurred between the parties. Nonetheless, the lower court held my client liable for intentional infliction of emotional distress based on these allegations alone. The tort of intentional infliction of emotional distress, as originally conceived, was meant to address truly egregious and objectively outrageous conduct. The standard was intended to limit liability to cases where a defendant's behavior would universally shock the consensus, and in this case, the plaintiff's perception of my client's actions is highly subjective and fails to meet this threshold. For example, in Osborne versus Keeney, this court clarified that intentional infliction of emotional distress requires that conduct that is ultimately intolerable in a civilized society. That standards exist to prevent minor annoyances or interpersonal conflicts from being transformed into actionable claims. While Ms. Kraft may have subjectively felt frightened, Mr. Rice's alleged conduct does not rise that level of erroneous required precedent. Maybe, for example, if Mr. Rice was holding a knife while making those threats, for example, then that would help to meet that requirement. But he did not. Traditionally, tort claims require a demonstrable objective injury, most often physical harm. The safeguard exists to prevent frivolous claims and ensure that liability is grounded in evidence. The absence of physical harm in this case undermines the reliability of the plaintiff's allegations. In Humana of Kentucky, Inc. versus Seats, this court recognized the need for clear evidence to substantiate claims of emotional distress. There, the court refused to allow recovery for emotional harm, while the plaintiff failed to demonstrate a sufficiently outrageous act. Similarly, in Kroger versus Will Gruber, the court emphasized that the conduct must cross a high bar of moral culpability, and in both cases, the plaintiff was denied relief, ensuring the emotional harms claims did not devolve into purely subjective assessments. The rulings against my client abandoned these safeguards, opening the door to a flood of claims based solely on subjective feelings without objective corroboration, which can allow all sorts of issues going on in the future because that would set precedent. The plaintiff's claims hinges on feelings of fear and intimidation, but her testimony lacks specific evidence of actionable conduct. She described her experience as being like a hostage situation, yet there's no evidence that my client physically confined her, such as marks on her wrist from holding her, or holding her inside like a house, for example, or any like marks for her to try to escape. There's none of that. Direct threats of imminent harm, such as subjective perceptions, cannot form the basis of liability. In contrast, with this case with Kroger versus Will Gruber, where the defendant's conduct included deliberate and malicious actions aimed at causing emotional harm. In that case, the conduct was deliberate, calculated, and you could demonstrate how outrageous it was. Here, my client's behavior, while perhaps unpleasant, does not reach this level. To impose liability based on subjective interpretations would create a slippery slope, inviting claims rooted in personal perception rather than objective wrongdoing. Expanding intentional infliction of emotional distress liability, as the court did here, risks unintended consequences. The recognition of intentional infliction of emotional distress without physical injury threatens to chill free speech and interpersonal interactions every day. Disagreements, heated arguments, or even misunderstandings could result in lawsuits. This court has previously demonstrated caution in expanding tort liability, as it should do so here as well. In Osborne, the court wisely imposed stricter evidentiary requirements to balance the rights of plaintiffs and defendants, expanding liability. In this case, disregards these protections, leaving individuals vulnerable to claims based solely on another person's subjective interpretation of events. For example, some people find being yelled at as a very stressful thing, especially if someone's, 6'5" and yelling at a woman that's 5'2". Obviously, that woman would find that very intimidating. But if you were to take another man that's, 6 foot and he was being yelled at by said person, it wouldn't be an issue because, essentially speaking, it's all about how things are interpreted. It's also about location. If you were to be yelled at, in your office, for messing up at work, that probably wouldn't be very intimidating because you messed up, so you're getting yelled at for it. So it kind of also depends on where you're at. So that interpretation kind of dictates these kinds of things. It is worth emphasizing that similar cases such as Humana and Kroger were resolved in favor of the defendants because the plaintiffs failed to establish the necessary elements of intentional infliction of emotional distress. These cases collectively demonstrate that this court has consistently required both objectively outrageous conduct and strong evidence of harm. The lower court's ruling against my client deviates from this well-established precedent, creating inconsistency in the law and the rulings held in this court. To further elaborate on that, in Humana, the court denied the plaintiff's claim because the alleged emotional harm was not accompanied by sufficient evidence of egregious conduct. Similarly, in Kroger, the court held that liability requires more than just offensive or upsetting behavior, otherwise we'd all be in court, because as it must rise to a level that would be intolerable or unreasonable to a person in a civilized society. The behavior alleged against Mr. Rice, while troubling, did not reach this standard. His actions were not calculated to cause harm, nor were they malicious or extreme enough to meet that legal threshold. Further, this court's decision in Osborne v. Keeney reinforced the necessity of clear evidence to substantiate emotional distress claims. In Osborne, the court emphasized that claims must be grounded in demonstrable harm, so that the standard protects defendants from frivolous litigation while preserving the integrity of the tort system. Allowing the verdict against Mr. Rice to stand undermines these protections that have been established by introducing a lower threshold for these tort claims, effectively creating inconsistency in the law, which, when viewed collectively, these precedents underscore a consistent approach of liability, which must hinge on the conduct that is both objectively outrageous and supported by the strong evidence of harm. The decision against Mr. Rice disregards these principles and should therefore be reversed. In conclusion, while emotional harm is undoubtedly a legitimate concern, the judgment against my client, Mr. Wright, represents a significant and troubling overreach in the application of the tort of intentional infliction of emotional distress. Which has historically been limited to conduct that is not merely inappropriate or offensive, but so egregiously outrageous that and intolerable that it defies all standards of decency in civilized society. The ruling in this case, however, discards that critical requirement of objective outrageousness and instead replacing it with a subjective perception of harm that varies widely from person to person. This departure from established legal standards risks setting a precedent where the boundaries of liability are no longer clear or predictable by permitting claims based solely on subjective emotional responses without requiring concrete evidence of extreme and outrageous conduct. Thus, the court risks unfairly penalizing defendants for behavior that, while unpleasant, do not meet the high bar of moral culpability required by the tort of intentional infliction of emotional distress. If this court affirms the rulings against Mr. Rice, it will open the floodgates to waves of lawsuits grounded in mere emotional discomfort or ordinary interpersonal conflicts. Such a precedent would expand liability to a degree that threatens the principles of fairness and predictability that are foundational to our legal system. Employers, neighbors, family members, and acquaintances could find themselves ensnared in litigation over situations that, while emotionally challenging, do not rise to the level of an actionable harm. Furthermore, this approach diminishes the seriousness of genuine intentional infliction of emotional distress claims by conflating extreme cases of psychological abuse with less severe subjective experiences. While emotional distress should not be trivialized, neither should it be weaponized as a tool for imposing excessive liability in cases lacking objective evidence of outrageous wrongdoing. The court has long recognized that tort law must balance the need to provide resources to victims with the imperative protection for defendants from overboard liability. By reversing the decision against Mr. Rice, this court can reaffirm that the stringent requirements for intentional infliction of emotional distress claims, ensuring that liability remains grounded in clear objective and egregious conduct. For these reasons, I respectfully urge the court to reverse the ruling, restore the boundaries of intentional infliction of emotional distress, and uphold the principles of fairness, consistency, and predictability in the application of law. Thank you very much for your time and consideration.